Welcome to another episode of the Federal Newswire Lunch Hour Podcast with your host, Andrew Langer.
Well, welcome to another episode of the Lunch Hour with Federal Newswire. I'm your host, Andrew Langer. Thank you so much for joining us today. If you're watching us, you can always catch us on whatever podcast platforms you want to listen to us. If you are listening to us on one of those podcast platforms and you want to watch, check us out on our YouTube channel. And please like us, leave us a review, make recommendations to your friends and your family members. We appreciate that. Joining me today is E. Donald Elliott. He is the Florence Rogatz Visiting Professor of Law at Yale Law School. He's been on the Yale Law School faculty since 1981 and currently teaches courses in environmental law, conservative legal theory, energy law, administrative law, and civil procedure. For 2013 through 2020, he was the co-chair of the Environmental Practice Group at Covington and Burling here in Washington, D.C. From 1989 to 1991, he served as the Assistant Administrator and General Counsel of the U.S. Environmental Protection Agency. In 1993, he was named to the first endowed chair in environmental law and policy at any major American law school, the Julian and Virginia Cornell Chair in Environmental Law and Litigation at Yale Law School. His latest book with Dan Esty is Advanced Introduction to U.S. Environmental Law. He was named one of the top 25 environmental attorneys in the United States by the National Law Journal and earned both his B.A. summa cum laude and Phi Beta Kappa and his J.D. from Yale. He testifies frequently in front of Congress on environmental issues. He has taught as a visitor at the University of Chicago Law School, Georgetown, Arizona State University, and the Antonin Scalia Law School at George Mason. He is a senior fellow of the Administrative Conference of the United States. We're going to talk about that. An elected member of the American College of Environmental Lawyers and the American Law Institute. He also writes a regular column about current events in the American Spectator and has published op-eds in many leading newspapers. And as I got to know him, Donald Elliott was the co-chair of the National Environmental Policy Institute's Committee on Improving Science at the EPA back in the 1990s. Donald Elliott, so glad you can join us.
Which is where I met my wife.
So there you go.
Exactly.
Well, you know something, and let's actually start there with that. You and I, before we started talking here on the podcast, we were talking about the 1990s as an interesting period in terms of regulatory reform and understanding the way science ought to inform regulations. Talk about that, but also talk about how we've sort of gotten off of all of that.
Well, I think that's a very important topic. First of all, on a lot of these issues, the first Bush administration in which I served and their successors in the Clinton administration were really not that far apart.
Right.
They both were pretty centrist. And when I was on panels with the Clinton people, I would always kid them afterward and say, well, we were to the left of you on environmental issues, and they would kind of laugh and say, yeah, that's true. But as a result, we were able to make some sort of centrist reforms. I think really the leader on that was C. Boyden Gray, who recently who recently died, and after whom the Administrative State Center at Scalia is named. And Boyden was really a wonderful mover on these kinds of issues. But I thought for a long time that the lesson to be learned from that, which is something that Mike Leavitt, a former administrator of EPA, had said, is that you can only really make permanent reforms kind of in a moderate way, because one of the underappreciated aspects of our separation of powers is the alternation of parties.
Right.
So, what you do in one administration can be undone in the next administration, and we've seen a lot of that in the Biden administration coming in and revoking a lot of the, I thought, very good things that the Trump administration had done, and candidate Trump has now promised to revoke what Biden has done if he gets back in. What we were doing in the 90s was basically quantitative risk assessment.
Yes.
Trying to make regulatory decisions more reasonable by putting them on a common scale.
Sure.
So we could really do the slogan is often worst first. That you try to focus on the big issues first.
Right.
But I think we've unfortunately lost a lot of that and have gone back to a system in which EPA and other agencies are really reactive to scare stories in the press. And if somebody calls something a forever chemical, everybody gets scared, and they don't really look at what the evidence, the scientific evidence really is. So we're spending billions of dollars today that I think really are unnecessary and wasteful. Tracing or really chasing, phantom risks that probably don't really exist.
It's interesting. So by background, my mom's an epidemiologist. My dad was an occupational safety and health scientist. And so this issue of risk and how risk informs public policy is it's important to me. It has a personal aspect to it because I talked about this with my dad all the time. And we talk a little bit more about this idea of quantitative risk assessment, comparative risk. It's something we all do on a daily basis. The idea of if I do X, Y or Z can happen. If I don't do X, these other things come out. Talk about this and why we're no good at it.
Well, this is one of the subjects that I teach. I have a lot of interest in toxicology and epidemiology and risk assessment, in part because I'm married to a PhD risk assessor and toxicologist who was recently on your podcast, Gail Charnley. That's what she's known as professionally, and she's known as Gail Charnley Elliott in her personal life. But one of the things I think people don't realize is that animal models of carcinogenesis are not really very good.
Sure.
So a lot of our concern is based on getting data that suggests that high doses can actually cause cancer in animals. And there's only about a 50% correlation between those animal models and outcomes in humans. And in fact, a few years ago, when there were really only 8 known proven human carcinogens, not a single one of them was positive in animal bioassays. So, I think now we've progressed a lot since then with what are called mechanistic data, which means really understanding how the chemicals interfere with the pathways and the biological processes within the body. But we still do quantitative risk assessment primarily through the the Office of Information and Regulatory Affairs at OMB, at OIRA. But I think the agencies have gotten very, very good at gaming the system and coming out with really huge estimates of the benefits.
Right.
So I've come around in my old age to the cynical view that most reforms wear out after 30 or 40 years.
Sure.
And that is because there really aren't any perfect mechanisms, and people always figure out a way to game the system.
It's interesting you say that because we're coming up on the 30th anniversaries. I think we're almost at the 30th anniversary of Regulatory Flexibility Act and the Small Business Regulatory Enforcement Fairness Act. And I like to think that those are great laws that should be maintained, but maybe you're right that we need to take a second look at such things to see how agencies are gaming the system in that regard. Let me sort of come back.
Can I just build on that for a second?
Yeah, absolutely. This is a conversation. So
one of my favorite quotes is by Coleridge, who wrote that reforms in every generation will be carried to extremes by weak minds. I always take out the weak minds part, and then become the occasion for reform in the next generation. Nice. And I think that captures a lot of it. And it's also not to get too academic, but it's also something that's been demonstrated in terms of game theory. Sure. In other words, years ago in the 70s, we thought that certain approaches, particularly cooperative approaches, were really dominant and would lead to better results for everyone. That was by a guy named Axelrod and Born Lomborg, who's famous because of his climate work. As a young game theorist, showed that that really wasn't true. Sure. It was only an artifact of if you only had two players, and if they built up a surplus, that becomes attractive for a third-party invader or pirate. So game theorists sort of say this by saying all equilibria are local.
Interesting.
Playing off of the line by Tip O'Neill about all politics are local. Yeah. So if you have a local equilibrium, it tends to be vulnerable to some counter strategy. Sure. And I actually said that to one of the smartest guys at EPA, a guy named Rob Brenner, who had degree in economics from Princeton, and Rob smiled and said, "Yeah, that's how we think. That's how we think too."
So let's sort of step back, because I want to come back to the 1990s, and it's funny because you were talking about your quote. One of the things in terms of sort of crisis modeled regulatory theory. A 1992 Supreme Court case, New York versus United States. I tend to quote that quite a bit. The Constitution protects us from our own best intentions. It divides power among sovereignty to resist the temptation to concentrate power in one branch as the expedient solution to the crisis of the day. In terms of immoderate change or non-incremental change, sweeping changes, this is how we get, going back and forth over the course of 20 years, the definition of waters of the United States. We still can't do that. Or the concept of how clean is clean, something, we worked on at the National Environmental Policy Institute, reinventing EPA project. We still don't have a good definition of that, and so we're sort of, we've gotten away from these things. And of course, this leads us in the end to having a regulatory state that is where costs really aren't considered anymore. We just sort of have an all benefits approach to things. And if you're driving things in a crisis, it leads us to, I would say, not solving environmental problems, but if we're not calculating the unintended consequences leading to other problems down the road. I know it's a complicated way of looking at things, but I wanted to get your thoughts on this.
Well, I don't agree with everything that you've said, but I agree with most of it. But I don't think that costs are irrelevant.
No, they're not. Costs aren't. I don't think costs are at all.
And I do think they're taken into account. I think it's a question of how much weight they get given.
Sure.
Part of the problem is that we've created a lot of single mission agencies like EPA, and the people and I think EPA is actually one of the best agencies that we have. But the people there are primarily concerned about protecting the environment.
Right.
And one of the things that is a feature of law is that it usually doesn't involve maximizing one value, but striking a compromise between multiple competing values.
Right.
And you asked me to come here to talk about an article that I wrote in the American Spectator recently about some of the objections to recent Supreme Court cases.
This is perfect
one of
segue.
which was on waters of the United States. Right. One of those cases, the Sackett case, where we've been struggling for over 30 years to define what a federally regulated wetland is.
Sure.
I remember back in the early 90s, Dan Quayle said, well, I think a wetland ought to have to be wet. And everybody made fun of him.
Sure.
But that's ultimately what a majority of the Supreme Court decided
Sure.
in this recent case called the Sackett case. I think that what's going on in a lot of these cases, or a lot of the criticism of the Supreme Court, is that the critics are not distinguishing between law and policy. And oftentimes they criticize the Supreme Court decision because it doesn't adopt the policy that they would like.
Sure.
And there's been a lot of criticism, for example, of the wetlands case on that ground, or the major questions doctrine, the West Virginia versus EPA case. But just sticking with the waters of the United States case, and this is one of the points I did not make in the article, but I should have.
All right.
One of my mentors, Bruce Ackerman at Yale, taught me that if an article is worth writing, it's worth writing more than once.
Of course, yes, I agree with that.
Because I find that when you write it the first time, you see how people misunderstand or don't understand some of the points and some of the things that you should have said. So what was going on when Congress enacted the Clean Water Act in 1972, Clean Water Act revisions? The federal government was basically taking over the regulation of waters of the United States from the states, and so there was a compromise.
Right.
If one looks solely at the question of regulating wetlands, you'd probably want to make sure that all wetlands, including upland wetlands that might drain into waters of the United States, are regulated. But Congress chose not to do that, in part because they were acknowledging that there was a substantial state role.
Sure.
And so they limited the federal role to waters of the United States, which are defined in terms of navigable waters, which is a traditional federal domain as opposed to a state domain. Of course. So if you look at it from the language of the statute, I think it's pretty clear that Congress did not authorize EPA to regulate wetlands that are not connected to waters of the United States. That's sort of the wording of the statute.
Sure.
But does that make sense from a policy standpoint if your only goal were to regulate wetlands effectively? No.
Yeah.
So in a lot of these instances, a lot of the press criticism that I was criticizing in my article is based on not adopting policies that people would like, or not recognizing that the language of the statute or the legal principle often involves more than a single value and the need to kind of reach an accommodation between them. And we can go down the list. But I agree with you. I think it's an outrage that it took us, I actually wrote an article in 2008 in the NYU Law Review saying it was remarkable that we hadn't been able to define what were federally regulated wetlands. And finally, in the Obama administration, EPA came out with a rule that said, well, ask us, and we'll give you a.
Sure.
So they got like 185,000 requests for interpretations. I saw the numbers recently. It was like over 90% of them, they would say, yeah, that's a federal wetland.
Sure.
I think what people don't realize is if a wetland is not regulated by the feds, it's regulated by the state.
Yes,
that's
exactly right.
What's underlying is a balance between federal authority and state authority, and a lot of the criticism of this decision and others' decisions is just misinformed because people, don't like the result, but but they also misunderstand it. They think that there's going to be no regulation of upstream wetlands.
Or they don't understand the constitutional principles that are involved. The federal government just doesn't have the power to regulate everything. That's,
I think that under the current law, the federal government would have power to regulate these wetlands because of the potential effect on interstate commerce the expansion of federal authority under the under the Commerce Clause.
So it's interesting because one of the early cases that I worked on this issue, I'm not a lawyer, but I've worked with some very talented lawyers in my time. A gentleman I was working for named Roger Marzullo was called in to testify on a wetlands case.
I know Roger very well.
Yeah. So, which is how you and I met many, many years ago. So, in which a gentleman was being charged with criminal violation of the Clean Water Act. And the federal government brought in a muskrat meat sales expert to try to develop that interstate commerce nexus, which is interesting. But actually it gets into, you talk about this misunderstanding, because a lot of the ire that at least I think surrounds the Supreme Court, or ire towards the Supreme Court nowadays, is frustration that the court is getting back to delineating those powers and the separation of powers and issues of federalism. And so I point out that we had roughly 60 years of expansion of federal government power from the Depression era and the New Deal era Supreme Court into the 1990s. In the late 80s and into the 90s, the Supreme Court started to announce some very bright lines in terms of federalism. And so we've had another 30 years of that. Presumably we'll have another 30 years, and then the court may take a different tactic. But I want to get your thoughts. I mean, are we really seeing over the last 30 years a return to these principles, or are we seeing an expansion into conservative directions?
Well, I will answer that question, but let me just go back to say that Congress does not always utilize the full extent of federal power.
Yeah.
And so there is a body of law which is quite controversial, particularly by my law school classmate Clarence Thomas, who was outraged about this even when he was a law student, that individual activities that, quote, have an effect on commerce can be regulated by the federal government.
Sure.
And he was particularly concerned about a case called Wickard versus Filburn, which actually was recently reiterated by the Supreme Court, that said a guy growing wheat for his own personal use and his family could nonetheless be regulated by the feds because by growing the stuff himself, he was having an effect on commerce. Yeah. But that doesn't mean that whenever Congress regulates, it's given the agencies that maximum extent of power. Going to your larger point about the current era and the current Supreme Court, I do believe that this is a kind of unique historic opportunity with what I see as a 3-3-3 Supreme Court to reconsider some of the more extreme rulings by the court that have been that have been on the books for a while, but really. I think what it illustrates is that, as you and I were talking about before we started, one of the underappreciated aspects of our separation of powers is the changes in leadership.
Right.
And we have now. I am not in favor of the current system in which we allow presidents to appoint Supreme Court appointees when somebody retires or dies. I've written something in the conversation proposing that every president ought to get an equal number of Supreme Court justices. So, for example, you had the anomaly that Obama got one and Trump got 3, even though Obama was in office for 8 years and Trump for only 4. And there is no constitutional principle that you have to have 9 justices to the Supreme Court.
Sure.
In fact, there's a really excellent article by Jonathan Turley, who everybody knows from Fox
Turley,
News,
sure,
arguing that the Supreme Court is too small. And that's what results in a lot of 5-4 decisions.
Sure.
Now, in fact, 50% of Supreme Court decisions are unanimous.
Yeah.
And 90% of Supreme Court decisions get at least one so-called liberal member of the court to join the majority. So I think the problem of so-called Supreme Court cases that are out of step with the will of the public, I think that's really greatly overstated. But it isn't really the rule. It isn't the role of the Supreme Court to do what the public wants.
Right.
It's the role of the Supreme Court to follow the law.
Yes.
And if the public has a different view of policy, then that's something that should be corrected by the political branches rather than by the Supreme Court.
Sure.
And I think that's the point that a lot of the liberal critics are missing.
Yeah.
Most of the pieces, including the article from the Washington Post that I cited in my article, don't even mention the legal principles that are involved or even the text of the law that's involved. They just say, I don't like the result.
Do you think, I want to talk about the administrative state, so if I don't get to that, remind me of this, but do you think some of this, again, before we came on, we were talking about the lack of civics education.
Yeah.
And do you think some of this has to do with that sort of a fundamental misunderstanding of, please
yes,
go ahead.
I do. I do. And I mentioned the fact that I am aware that some of the students, even at supposedly advanced universities like the one I teach at, are not familiar with how laws get passed.
Right.
That there are 2 houses of Congress, that the president can veto bills, and then they can be passed over the president's veto. And this is because we no longer teach those basic things that, by the way, all citizens are required to know. All new citizens are required to know to pass the citizenship exam. And I do think there's some great efforts going on. I recently learned that Doug Ginsburg, a senior judge of the D.C. Circuit, has been behind a big program to try to start teaching high school civics again. So I think that's important. The other factor, though, that I think is really important is most of the journalists who are writing about this stuff don't know the basic principles.
Right.
And when I first went up to Yale and started teaching in the early 1980s, the Ford Foundation had a program that would bring journalists to Yale for 1 year of legal education.
Wow.
And they get some kind of master's degree or whatever. And that was very useful. And for some reason, they stopped doing that. But I think the level of legal journalism in the United States, not in specialized publications, but in general publications, is really rather low.
And so much of it now is focused on frippery and personality and scandal and not on the substance of the law, which is
that's right. That's right. And I do think that it is a unique opportunity to revisit some of the issues, delegation and other issues that the Supreme Court, I think, will be revisiting over the next few years. I was recently invited to lecture to 30 federal judges and state Supreme Court judges, and I spoke about the unique developing opportunity to reconsider some of the principles relating to the administrative state if I can put in a
please, because I want to talk about this.
If I could put in a plug for a book that I didn't write.
Okay.
There's an excellent book by Peter Wollaston, who was formerly at the American Enterprise Institute, called Judicial Fortitude.
Yes.
And he does an excellent job of setting out the history and arguing that this is published in 2018, and suggesting that it's an opportunity for the courts to revisit some of these things. That said, I am not an abolitionist with regard to the administrative state.
Yeah,
Many people are.
Philip Hamburger at Columbia is one of them.
I'm an ameliorist, and actually, I believe in correcting some of the abuses of the administrative state. But I think the increasing role of experts in making law is a worldwide phenomenon.
Right.
I don't think, and this is a point that Peter Wollaston makes in his book, I think the American people expect a much broader and more active federal government than the one that the framers essentially originally.
Yeah.
So I don't think we're going back to what is sometimes deprecatingly called the night watchman state.
Right.
I think the problem is how to make these administrative agencies more respectful of the basic constitutional design. And I've got a lot of ideas about how we do that. I think that this goes back to an early error by Chief Justice Marshall in a very famous case called McCulloch versus Maryland,
sure, of course, yeah.
which held that the federal government could create a bank, even though that had traditionally been done by the states. And the argument by Maryland was that this wasn't really necessary.
Right.
And so most of the opinion is about that. And the word proper got kind of lost in the shuffle. And for a long time, the Supreme Court just said there's no independent meaning to proper.
Right.
It's just necessary and proper is like one compound noun.
Okay, sure.
And in fact, John Roberts, much to his credit, tried to correct that historical error in the Obamacare case by saying, well, no, proper has an independent meaning.
Yeah.
And it means fit or suitable.
Right.
And what it really means is that although Congress can create new institutions, their design, in my view, has to be consistent with what Marshall calls the spirit of the Constitution. Right. And one of the examples of that, for just to take a particular example, is James Madison says it's the height of tyranny to have one element of government exercise all three powers, legislative, judicial, and executive, and yet many administrative agencies do that.
Yeah, I've had conversations with folks about
They make the rules, they make the prosecutorial decisions, and they have their own little judicial system within the agency.
There's a reason why the FTC has never lost a case in the FTC's administrative courts.
Yeah, that's right. I recently heard somebody who had been on the FTC talk about that, and they have apparently one administrative law judge who rules against them 50% of the time, but then is subject to appeal to the full commission, which goes back and reinstates the initial verdict. But one of the reasons we haven't really been able to change this is it's so expensive to litigate against the federal government. The Sacketts are a perfect example. There's a poor couple that has bought a piece of property, and the EPA decided that it was a wetland, although it's not wet. And they've been trying for 20 years to build something on their property where all the other properties in the neighborhood, no problem. And luckily, they were represented by an NGO.
Oh yes, we had on Jeff McCoy from the Pacific Legal Foundation.
Good.
So.
Well, but a very important case was recently decided, which is typically called Axon versus FTC, which holds that parties can challenge the structure of an administrative agency without going through the whole process of exhausting administrative remedies.
That's interesting.
That was also a case that was brought by something called the New Civil Liberties Alliance, which was founded by Philip Hamburger, and I'm on their advisory board. They brought the companion case, and unfortunately for them, the case is getting known by the Axon versus SEC aspects of it rather than Cochran. But in any event, doesn't matter. That will make it much easier for parties to raise these issues in the courts.
So getting back to this issue, right? And I love this because I also want to talk to you about the work of the Administrative Conference in the United States. Paul Verkyle, who I've known since I was at William & Mary. I'm a huge fan of his work over the years. But some of this is the growth of executive branch power and the power of the administrative state is when Congress doesn't step in and get more explicit in terms of statutory language. Now, I know obviously Congress can't. This is what we call in terms of governance by experts. Congress is not necessarily an expert on things, so they can't define terms as explicitly as some might like. But on the other hand, the more vague Congress leaves statutory language, the more opportunity there is for agencies to interpret statutory language to their own benefit or to the benefit of the growth of the agency. Your thoughts on that?
Well, I think that's right. David Schoenbrod, who teaches at New York Law School, wrote an excellent book in 2009 about Congress and delegation. And I think what David saw in that book is that Congress wants to avoid making the hard policy decisions.
Yes, believe me, I've said that myself.
Because the hard policy decisions, offend somebody.
Right.
So if they can, often in order to get something passed by the majorities that are required, you have to be vague, because if you specified the outcome one way or the other, you couldn't get it passed.
Yeah.
This is one of the things I don't think the court appreciates. There's an excellent concurrence about the major questions doctrine in the recent decisions invalidating Biden's attempt to forgive all these student loan payments by Justice Barrett. But I think, and it's really an excellent opinion and very thoughtful. She does make one mistake, though, and that is she assumes that Congress is going to want to make all the big decisions. Right. And unfortunately, part of the problem is you're going to have to force Congress to make these decisions.
I had that conversation with a member when I was lobbying for the National Federation of Independent Business, and he wanted me to blame the agencies. And I said, well, no, Congressman. Yeah. If you guys were a little more explicit, we might not have some of this problem. But you're absolutely correct.
That was one of my fondest moments when I was at EPA. I was testifying in front of Senator Glenn and the former astronaut, and he was upset about something I'd said in my confirmation hearing about how I thought it was crazy that the leachate from a Superfund site had to be cleaner than the municipal drinking water in a major city. And he said, "Now, Mr. Elliott, what damn fool at the EPA made that decision?" I was quiet for a moment and let the suspense build, and I said, "Well, you did, Senator. It's written into the statute."
That's the statute,
but the statute is written in a way that no member of Congress would really have understood what it meant, because it says the MCLG, which is the maximum contaminant level goal, which is often zero, has to be applied to Superfund sites, where in the actual drinking water system, you have a maximum contaminant level, which takes economics and costs into account and is often a lot higher. So, it's a basically structural problem, and I wouldn't blame it all on the agencies. Sure. But my experience is that people in agencies tend to be very highly motivated by a single goal.
Sure,
and,
of course.
If you're in the Department of Transportation, it's about building highways and improving the transportation system. Similarly at EPA, and that's why the Office of Information and Regulatory Affairs at OMB was created, is to try to harmonize these values. And I have great hopes for the new administrator there, Ricky Revesz, who you might want to have on, actually.
I will reach out.
Ricky is a former student of mine and a friend, and I helped him set up his institute at NYU. He's an economist, and I have great hopes for him.
As I've said to several former OMB directors on the podcast, the OIRA administrator job is my dream job in Washington, D.C. And that to me is such a vital role. And anyway, I'm sorry. Go ahead.
Well, the Bush White House wanted to appoint me for that job, and Dick Darman, who was the head of OMB, vetoed it without meeting me by saying nobody who'd ever worked for Bill Riley could ever work for me.
That's interesting.
So it was kind of funny, but I've been very interested in OIRA and been close to a number of the OIRA administrators over the years. And I think it's been really a positive thing. There are some limits to it. It only applies to rulemaking, as you know. And also the staff is really very small. And I think the agencies have gotten very good at coming up with really large benefits that sort of swamp the costs.
Well, this is, and that's just it, right? When you're talking about a regulatory state that is as massive as it is, and regardless of whether or not you agree with regulation or you want to, make the regulatory state smaller, to have an OIRA administrative staff that is so small, given the size of the regulatory state, there needs to be more of this. I want to come back to this issue of parochialism, right? Yeah. And I don't mean that in a bad way. I just mean, you're right. You have agencies themselves that are single-minded. You have offices within agencies that can get single-minded. And so there, even when you have cross-communication, that's how you get, the Office of Air, putting out a rulemaking saying that if you have a business that has a non-paved driveway, if you want to reduce particulate matter emissions into the air, you have to pave over the driveway. And then the Office of Stormwater Management comes in and says, well, wait a minute, if you pave it over, all of a sudden you've got this runoff problem. So now you have to rip up what you've done and you have to, put pavers in or you have to do something else. By the same token, we have, not that you necessarily want to talk about this, you have things like EPA wanting to regulate ethylene oxide, which is a disinfectant, but not talking to the FDA about it, and the FDA saying, well, you haven't given us an alternative to it. So, on the one hand, we get why you want to regulate this as under emission standards, but we need to be able to disinfect medical devices. That's really what part of what we're talking about here is the single-minded approach. And again, this is where comparative risk assessment or quantified risk assessment comes in handy, because if you're looking at what the other agencies are looking at in terms of the risk trade-offs, you get better policy that serves people better.
I agree with all that. Yeah. And it's not just risk assessment or quantitative risk assessment. My friend Cass Sunstein, yep. who teaches at Harvard and
wrote the book Risk and Reason.
Right. Yeah. And was head of the Office of Information and Regulatory Affairs under the Obama administration, said that the biggest shock to him when he went to OIRA is it wasn't all about benefit cost analysis. Yeah. It was about interagency review.
Sure.
It was about when one agency wants to put up a rule, the other agencies get to comment within the executive branch before it goes public. And that was also my experience in government and in the 30 years I've been practicing law since. And in fact, this was the original purpose for creating OIRA. Yeah. It was originally proposed in an article in the Yale Law Journal in, I think, 1969, wow. if I remember correctly. And it was an article written by Lloyd Cutler, who subsequently became counsel to the president in the Clinton administration. And it was Cutler and Johnson, and they were concerned about the single mission nature of agencies and the need to harmonize competing values. And that, I think, is very much the case. I mean, the case for expertise is that all of us have kind of limited cognitive capacity. Right. And so you develop expertise by focusing a lot of your attention on a certain set of issues.
Absolutely.
But that comes at the cost of, not, and I actually figured this out pretty early. I was influenced by a wonderful academic named Herbert Simon, who talked about limited cognitive capacities. So I consciously decided there's certain things that I don't pay any attention to.
Sure.
So I try and free up cognitive capacity. And just one more quick point.
Absolutely.
And that is, the brain science now confirms that each person during their lifetime, you can't erase anything in your brain like you can a computer.
Sure.
So because when you have an experience or you remember something, it makes physical changes in the brain. So your brain can record about 4 trillion data bits.
Sure.
And in your lifetime, you get to pick which 4 trillion, but you can't really expand beyond 4 trillion.
So there are Homer Simpson was right. Homer Simpson said the same thing to Marge. He said, every time I learn something new, something else goes out of my brain.
Well, it doesn't go out of your brain, but you miss the opportunity. And so, for example, I know nothing about macroeconomics or pop stars. I'm always when there's a crossword puzzle that has the name of somebody who sang this hit in the 1990s, I always get stumped by that. But I think we all know some things, and this is actually something that Will Rogers said. He said we're all ignorant just about different things.
Right. Or Fred Smith, my boss at the Competitive Enterprise Institute, used to say people are stupid because they're smart. which I love. Let's pull it back a
Yeah, and
little
I
bit.
wrote one called The Smarts Fallacy.
There you go.
Which is the other side of that. That's also in the American Spectator, about how the fact that somebody is smart on one thing doesn't mean they're smart about everything. And nuclear physicists are the worst in this.
Sure.
They think that because they understand, particle physics, that makes them experts on international relations.
Do you think that's one of the great problems we have in D.C. nowadays, that people can't admit when they don't know something? They can't admit when they're wrong. They can't admit that they don't have a sense of knowledge, that they're somehow they're penalized because they don't know, if you're a nuclear physicist, that you should know something about international relations. Do you think that's something that's wrong in D.C.?
Yeah, but I don't think it's a problem that's limited to D.C.
No, of course. we're talking public policy in D.C. So yeah.
I mean, I think that I think the biggest problems in D.C. have to do with the decline of the role of Congress.
Sure.
And
I agree with that.
And that has then I recently learned, fed back into the hollowing out of congressional staffs.
Yeah.
You don't really have the kinds of career experts.
Oh, sure.
At the at the committee level,
right,
or much less the individual Congress level that you used to have. And that's because there's very little for them to do. The Congress is, most people don't know this, but individual members of Congress can write bills and introduce them, but they can't get anything passed.
Right.
In order to get, all these legislations today, or most of them, are in these, huge bills that are thousands of pages long, and they give them to people in the Congress, including the committees with jurisdiction, 24 hours before they have to vote on it. And it's not, in most instances, particularly in the Senate, it's not possible to amend them. And so I think that's really the biggest problem. And then what's happened is that because Congress is not making a lot of these policy decisions, that defaults, somebody has to make the decision.
Yeah.
So it either gets made in the agencies in the first instance, or it gets made and reviewed in the courts. And both of those are essentially non-democratic institutions. There is this sort of legal fiction that the administrative state is responsible to the president who is elected. But my experience, and we could talk about some specific examples, is the president has relatively little control over the agencies. It's pretty hard to control the agencies. And I remember one time when something at EPA, one of the career staffers objected to me about what he called political interference, and told me it was my job to keep the White House off his back. And one of my students at Yale, who went on to be assistant solicitor general for the state of Indiana, a guy named Kyan Hudson, pointed out to me that what this guy was calling political interference was what we might call democratic political control.
We just recently had on David Bernhardt, who was the Interior Secretary, and we just wrote a book about this called "You Report to Me," which is about this. I want to take a step way back here, because I think it's helpful for folks to understand who you are and sort of where you come from. Tell us a little bit. Were you always interested in environmental policy or scientific policy? How did you come to find yourself as general counsel of the EPA? How did you get interested in these things?
Yeah. Well, I was always interested in the relationship between law and science.
Yeah.
And when I was in college, I read a number of books by Barry Commoner about environmental policy. And so it was one of the things that I was interested in. When I was at Yale, they didn't give a course in environmental law. And when I clerked for David Bazelon on the D.C. Circuit, largely because he was the federal judge that was most interested on the relationship between law and science. Yeah. And I remember when I was clerking, he assigned the insanity defense cases to my co-clerk from Harvard. I thought my life was ruined. And he took me aside and said, "No, Don, these environmental cases, which are just starting to come through the courts, are actually going to be more important in the long run." So I won't go into the whole story, but I was raised as a Presbyterian in southern Indiana.
Okay.
And one of the things that the Presbyterians believe is you don't pick your profession, or at least you shouldn't. You are called to something, and your job is to figure out what your calling was. And so the environment kept choosing me despite my closing my eyes to it. And when I went to work for a law firm, it didn't have an environmental practice, but I still went to work for that law firm. And about 3 months later, a wonderful man named Roger Strelo, who'd been chief of staff at EPA and ran the air program, came to the law firm, and they sent a memo around saying, "Does anybody know anything about the environment?"
Sure.
And I'd worked on it. So Roger became one of my mentors.
Interesting.
And then, for reasons that I don't need to go into, the person who'd been teaching environmental law at Yale Law School left to go to Columbia for a few years. And so they needed somebody to teach environmental law. So it just kept happening.
Yeah.
And I managed to get the job as general counsel of the EPA because I was everybody's second choice.
Sure.
I became acceptable.
This is ranked choice voting. Then.
Right, exactly.
Yes,
I was acceptable to Bill Riley, the incoming, and I was also acceptable to the White House.
Sure.
And so it's a matter of having been sort of a compromised politician in some ways.
If you had a time machine and you could go back and talk to yourself, what advice would you have given yourself at, knowing what you know now, what would you have told yourself?
That's a great question.
General counsel of EPA?
That's a great question.
Thank you.
So one of my predecessors was a wonderful man named Frank Blake, who was actually Boyden's chief assistant in terms of doing regulatory reform. Then he was general counsel of EPA. He went on to be the chair of Home Depot.
Okay.
But Frank said to me one time, "Don, when you get out of the job, you'll see things that you weren't smart enough. You could have done something about, and you weren't smart enough to do it at the time." And one of the things that is a good example of that is I signed off on the expansion of this in-house judicial system at EPA, and I think in retrospect that was a big mistake. I got better as I was there for a while. In my second year, I was better than in my first year.
That's a good thing.
And one of the things I learned, and my career deputy said, if you could only stay another year, we'd actually be able to get something done.
Yeah.
But I had to go back to Yale. And so I think that there are lots of things that you would have done differently if you had more knowledge, and you have to sort of live with it thereafter. And that's one example that occurs to me, and I think that's why people like this idea of going back.
Sure.
If after you had completed the third grade or the fourth grade, you could go back and do third grade again.
Sure, of course.
You do a much better job. This is a variation of what's sometimes called the Peter Principle. I don't know if you remember that article.
Absolutely. Everybody rises to the level of
incompetence. Yes. And I think that that's certainly true in those government jobs. And I think most people are better off in their second tour of duty in government than in their first.
Sure.
It takes a while to learn the ropes and learn how to do things.
Well, Donald Elliott, thank you so very much for joining us today.
It's over already?
Yeah, I know. It's
fun.
been,
That's great. Thank you.
So thank you all very much for tuning in to yet another episode of The Lunch Hour with Federal Newswire. Our guest has been E. Donald Elliott. You can find him online. His great writings are certainly online. Please check us out. Leave us a review. Leave us a thumbs up. Subscribe to the podcast both on YouTube and wherever fine podcasts are found. I'm Andrew Langer, your host. Enjoy the rest of your lunch.
This has been the Federal Newswire Lunch Hour Podcast, hosted by Andrew Langer. Check out the Federal Newswire's family of websites, as well as their social media stream.